The trial in the case of the prosecutor against Dominic Ongwen has entered its final stages, following closing statements that took place before Trial Chamber 9 of the International Criminal Court from 10th to 12th March 2020. During the closing statement hearings, the prosecution, the legal representatives of victims, and the defense presented their final arguments before Trial Chamber 9, composed of Judge Bertram Schmitt, Judge Péter Kovács, and Judge Raul Pangalangan. The accused, Dominic Ongwen, was present in the courtroom. Dominic Ongwen, the alleged former commander of the Senior Brigade of the LRA, is accused of 70 counts of war crimes and crimes against humanity, allegedly committed during a widespread and systematic attack directed against the civilian population of northern Uganda from at least 1st July 2002 to 31st December 2005, including the attacks against the civilian population in Lukodi, Pajule, Odek, and Abok IDP camps between October 2003 and June 2004. During the hearing, the prosecution team, composed of Mr. Benjamin Gampert, Ms. Adesola Adeboyejo, and Mr. Colin Black, addressed several issues regarding the case, such as the abduction and conscripting of child soldiers in the LRA, attacks against civilian population in Lukodi, Pajule, Odek, and Abok IDP camps by the LRA, sexual and gender-based violence caused by the accused and LRA soldiers, and the LRA as an organization. The prosecution team also addressed some arguments the defense made in its closing brief, such as the unfairness of this trial, the modes of liability, the intercepted LRA communication, and the accused mental state during the charged period. Mr. Benjamin Gampert, OTP senior trial lawyer, made submissions about the abduction of child soldiers in the LRA and the role of the accused.
Boys were abducted to become LRA fighters, and girls were abducted to become forced wives and domestic servants or babysitters, known as ting-tings. Every unit in the Senior Brigade had children under 15 in its ranks during the charge period, and abductions were a standard part of Senior Brigade's operations. Children, including children under 15, were abducted to fill the ranks of the brigade during the charged period. The preferred age for the abduction of boys was around 12 years, although boys sometimes as young as 8 or 9 were abducted as well. After abduction, boys usually underwent a ritual and were beaten as part of their initiation into the LRA. They were trained with weapons. They were taught about LRA rules. They were assigned to particular fighters, often the ones who had abducted them. When they were deemed sufficiently reliable, abducted boys, including boys under 15, were armed with guns. They were used as escorts to commanders in the Senior Brigade. They were placed in observation posts. They acted as guards and carried food, weapons, and ammunition. They took part in attacks on civilians, in ambushes, and in battles with the Ugandan army, the UPDF. And they were used to kill, to pillage, and to abduct. Mr. Ongwen was a member of Senior Brigade's leadership throughout that charged period of 42 months, first as battalion commander, and from March 2004 onwards as the commander of the whole brigade. Together with his perpetrators, co-perpetrators, other members of Senior Brigade leadership, and Joseph Coyne, he pursued a common plan of abducting children in northern Uganda and conscripting them into the Senior Brigade to ensure a constant supply of fighters. As a result, children, including children under 15, were conscripted and used to participate actively in hostilities. Mr. Ongwen, amongst other things, ordered abductions, monitored the training of children, himself used children under 15 as escorts or part of his entourage, and deployed children on military operations. He regularly interacted, as your honours have heard, with those children. On occasion, he even specifically inquired about their ages. He knew full well that amongst them there were those who were under 15.
Mr. Gumpert also went on to address the specific charges against Mr. Ongwen related to the attacks in Pajule, Odek, Lukodi, and Abok IDP camps. Specifically, in relation to Pajule IDP camp, he said,
"The prosecution say that the evidence in this trial concerning the attack on Pajule has proved beyond reasonable doubt that in the days leading up to the attack, Vincent Otti, deputy commander of the LRA, ordered other commanders to meet him in Péter in northern Uganda. Mr. Ongwen responded to that call and he joined Otti on the 5th of October 2003. Shortly before the 10th of October 2003, Otti, Mr. Ongwen and other senior commanders agreed to attack the IDP camp at Pajule. LRA fighters converged about 10 kilometers east of Pajule, near a place called Wanduku, and it was there that the fighters were selected to participate in the attack. Mr. Ongwen instructed some of his subordinates to select LRA fighters to form part of the attacking force. At dawn on the 10th of October 2003, LRA fighters attacked the camp. They were divided into 4 groups. The overall commander on the ground in charge of those groups was a man called Raska Lukuya. Mr. Ongwen's role was to lead a group to attack the trading centre at Pajule. The attack caused havoc. Civilian inhabitants were murdered and they were abducted in their hundreds. LRA fighters in Mr. Ongwen's group broke into shops and civilian homes. They pillaged a variety of items. They abducted civilians at gunpoint and forced them to carry those looted items. Civilians who were unable or unwilling to carry items given to them were either beaten or ultimately killed. And Mr. Ongwen was present at the centre of the camp when this occurred. After the attack, Mr. Ongwen and the LRA attackers returned to a rendezvous point. We've referred to them consistently as RVs. And they took with them the items they had pillaged and a large number of civilian abductees. Ultimately, the LRA released most of the abducted civilians, but they kept the younger ones to serve as new LRA fighters or forced wives, or for the younger girls to act until they grew older as domestic servants.
The senior trial lawyer also submitted that the prosecution had shown through its evidence that Mr. Ongwen was aware of the persecution some civilians faced in northern Uganda whom the LRA felt were supporting the government, and he supported this campaign against those civilians with his actions. He noted that the prosecution doesn't deny that Mr. Ongwen was a victim of abduction, but that this should not warrant immunity for the crimes that he committed while he was in the LRA. Ms. Adesola Adeboyejo, the OTP trial lawyer, further addressed gender and sexual-based crimes. She narrated in gory details the evidence of witness P226.
He shut the door. He asked me to undress. He undressed me as well. He asked me to spread open my legs. He took hold of his penis. He put it in my vagina. And he started forcefully having sex with me. I started crying. I was screaming, and my voice was really loud. He asked why I was crying. He told me that if I continued crying, he showed me his gun. The gun had something sharp on top of it, like a bayonet. I felt like my whole body was being torn apart. He was actually having sex with me in the anus as well, for a very long time. The testimony of Mr. Ongwen's first wife, P227. Mr. President, Your Honors, the evidence that Dominic Ongwen personally committed sexual and gender-based crimes against civilians during the course of violence by the Lord's Resistance Army in northern Uganda is compelling. The slide before you is an example. But the defense, who challenged this witness, mainly on the anal penetration aspect of what she said, argue that Mr. Ongwen is not guilty of crimes against this witness or any of the other 6 witnesses who gave similar account of how they were the direct victims of his attacks on them. They argue that he did not intend to commit these crimes. They appear to argue that he cannot be blamed for what he did because of his poor mental health when he raped these witnesses. They also argue that he was acting under duress, that the hearings at which these women testified were procedurally defective, that the geographical parameters of the charges were not clearly specified, and that the witnesses were confused during the Article 56 proceedings. Your Honors, I want to look at these various aspects of the defense's claims. The prosecution's case is that Dominic Ongwen personally committed different types of sexual and gender-based crimes, including rape, forced marriage, sexual slavery, and forced pregnancy against 7 women, P99, P101, P214, P226, P227, P235, and P236. He not only personally committed these crimes, but he also made fighters of his senior brigade, of which he was commander, carry out similar brutal crimes.
On the second day of the hearings, the 2 teams of the legal representatives of victims submitted their closing statements before the chamber. Mr. Joseph Manoba began his presentation by reading the brutal accounts of his clients, the participating victims, of how the LRA had attacked, pillaged, killed, maimed, and wounded civilians and their properties in northern Uganda during the charged period. He also addressed the grim situation of the civilians who were forced to live in IDP camps due to the insecurity in northern Uganda. He described in details the harsh and challenging living conditions at the 4 IDP camps, which included sickness, hunger and malnutrition, insecurities, and attacks which affected many civilians who suffered and some died. Mr. Manoba further said that the Ongwen trial marked a phase of recovery from a dark past for the victims participating in this case.
Mr. Ongwen and the LRA benefited and drank from what we would term as the spoils of the armed conflict. and left behind broken individuals and shattered communities, destroyed all sources of basic human living and sustenance, resulting in life of deprivation. Their acts of terror created memories of the lives of loved ones wasted in burning houses, shot down with bullets, and others battered to death in barbaric fashion, as though bloodshed and life were meaningless. A history of productive life replaced by a revolting life of squalor in the IDP camps. Your Honors, the African child, who was the source of hope and a transformative future, replaced with a life of illiteracy, frustration, misery, envy, alcoholism, and land conflicts, amongst others. This past is one which the victims that we represent do not wish to see again and would not survive if it were to reoccur. It is the victims' hope that through this trial their experiences have been heard, and Mr. Ongwen is and will be held responsible for his actions and omissions as an LRA fighter and commander, as we heard from the prosecution yesterday. And this trial can be a great message to all those outside there who wish to act in the same way that Mr. Ongwen and others may have acted, that tolerance and love for peace and togetherness can be achieved without resorting to violence and or committing atrocities in society.
The legal representative for victims, Francisco Cox, also took the floor to discuss in details the consequences of crimes that their clients, the participating victims, faced during the charged period and beyond. Consequences of crimes included broken homes and families, which this conflict caused, physical and psychological trauma that victims have and continue to suffer from, the stigma faced by returnees who came from the bush, as well as economic and financial consequences. He further discussed the victims' expectations of the proceedings.
For most of the victims, the opportunity given by the court to be represented by the lawyers in the proceedings, to express their views, their concerns, and convey their questions has been a first of its kind for them and is greatly appreciated. However, despite the unprecedented scope of charges brought by the prosecution against Mr. Dominic Ongwen, the evidence presented by the prosecution did not fully portray and totally portray the suffering of the victims. Some of the more grievous forms of torture and humane treated meted out by some LRA rebel fighters were not shown. During the course of the engagement with our clients, several victims opened up and conveyed to us that rape occurred also during the attack against both male and female members of the community. Evidence presented by the prosecutions confirmed this view. Witness 187 testified how she was raped by an LRA fighter in the aftermath of a Lukoti attack. She was abducted, forced to carry looted items, raped by the LRA fighter, and released. The LRBs would like to therefore emphasize that the harm suffered by victims goes far beyond the material presented by the prosecution. The participating victims we represent know that whilst they have been fortunate to meaningfully participate in these proceedings, they are aware that many others were not given the same opportunity because of the time limits set by this court.
From the Office of the Public Counsel for Victims, Ms. Paulina Masida, Principal Counsel, took the floor to make submissions on behalf of her clients, victims participating in the proceedings. She discussed a few issues: the LRA policy of attacking civilians, abducting girls and women, as well as children under the age of 15, criminal liability of Mr. Ongwen, and the expectations of victims. Ms. Masida began her presentation by narrating the atrocities as well as the increased tension and episodes of violence that her clients suffered since the 1980s, when the LRA and UPDF started their conflict. Ms. Masida also addressed the criminal liability of the accused.
It is not disputed that Mr. Ongwen might have been a victim of one of several crimes when he was a minor. However, this fact alone does not constitute a legal basis for excluding criminal liability under the Rome Statute. The fact that Mr. Ongwen has been abducted at a young age does not absolve him from criminal liability for his acts and conduct as an adult. By arguing once a victim, always a victim, the defense not only negates the paramount principles of human resilience and agency, but it also fails to acknowledge blatant facts, such as that not all victims become perpetrators and criminals, let alone powerful and cruel ones. The event Mr. Ongwen might have been a victim as a child when abducted are extraneous to this trial. What this trial is about is the conduct of Mr. Ongwen as an adult and the actions he chose to take or not to take at the time of the charged crimes.
On the third day of the closing statements hearing, the Ongwen defense team made their submissions before the chamber. The lead counsel, Crispus Ayena Odon, began his submissions by noting that the accused, Dominic Ongwen, was a victim. He reminded the chamber that the accused is an orphan who suffered traumatic events under the LRA regime for over 20 years. Mr. Ayena asked the chamber to acquit the accused, but requested that should the chamber issue a conviction, then let the sentence be mild. Additionally, he asked the chamber to release the accused back home under the care of Acholi elders.
Your Honors, Mr. Ongwen, who is before you, was just a child when he was abducted, brutalized, and made into a fighter machine without a mind of his own. He is a victim, just like former soldiers who managed to escape and are now participants in this courtroom as victims. Your Honors, whichever way this case is decided, Mr. Ongwen is entitled to all or any of the reliefs given to the other victims. He is a victim, and this point, Your Honors, is not contested by the prosecution. Neither has it been contested by the victim's counsel. This case is an indictment, therefore, of the government of Uganda, and indeed the international community, especially those countries who, instead of intervening to discourage the government of Uganda from prosecuting the war against the LRA in a manner akin to ethnic cleansing of genocidal proportions, instead funded and perfected its war machinery of mass destruction, considering the types of weapons the government of Uganda acquired from them and used to fight an ill-armed rebels within the civilian populations. When deciding who was responsible for the death in the IDP camps, Your Honors, I call upon you to consider the type of weapons, guns which were used, and particularly bearing in mind, Your Honors, that it has been shown through witness evidence before you that LRA just had light machine guns where you find bombs. Find fault with the government of Uganda soldiers. And my lords, I want to raise these pertinent questions that should be borne in mind when you consider this case. Number one, apart from the preliminary issues relating to fair trial violations, Your Honors are asked to determine, firstly, whether the accused qualifies as a victim. Although I know I have already said this is not contested. And then secondly, whether having been abducted as a 9-year-old child who spent nearly 27 years under LRA, Mr. Ongwen, at the stroke of midnight of his 15th birthday, transcended into an adult in terms of mind transformation and thereby became a perpetrator of the crimes he's charged with. We submit that the prosecution has been at a tangent with the factual situation of this case. They turned their back to the core issues, which is the character of the LRA. They ignored the effects of spiritualism on the mental state of Mr. Ongwen. And when you're talking about the mental state of Mr. Ongwen, unfortunately, they think that what is relevant, the period that is relevant for assessing his mental state at the time is alleged to have committed the crime, was the charged period. They have totally forgotten that it was the cumulative effect of what he went through immediately after his abduction up to the time of his escape and surrender to this court. And at this point, Your Honors, I think I want to put this matter of whether Ongwen was arrested, captured, and brought to court, or he actually surrendered. I don't have to emphasize this, Your Honor, Your Honors, but I know that it has been paraded, either in the mass media or even in this courtroom, that Ongwen was arrested and brought to court. No. Evidence abound that Ongwen, at the glimpse of an opportunity, escaped from the grips of Joseph Coyne, like he had been trying for many years, and surrendered to this court. And I think when you are considering this case, this must be taken into account.
The defense lawyer, Beth Lyons, requested the chamber to issue an acquittal of Dominic Ongwen.
I think at the end of the day, it's going to be necessary for those who are judging the case to put themselves in the shoes of Mr. Ongwen, in his mindset, in the environment of the bush. And for many of us, this is simply not possible even to fathom. But it is the task that those who are judging this case, I think, may have to undertake. Mr. Ongwen is not just a person sitting in the back, flanked by security officers, who's been here for a couple of years, whose mental health has been analyzed and dissected, talked about in front of him collectively by 5 experts at least. He's a victim. In his own words, he says he survived the LRA prison. Those are his words, which he agreed I could use. This controlled his life for 27 years. And he survived, and he will survive the process however it ends. And it's now actually in your hands. We've, of course, asked for acquittal on all counts based on our affirmative defenses. But if the trial chamber reaches any verdict of conviction, we are also asking, which lead counsel will elaborate on, we were asking the chamber to suspend punishment and return Mr. Ongwen to Acholi land in the care of the elders so that traditional mechanisms of matu aput can be implemented. It's the defense view that this would best serve the interests of justice for Mr. Ongwen and for the community of which he's a part. And for the ICC, it's also our view that this would demonstrate its spirit of complementarity and cooperation with the existing cultural processes.
The trial chamber will make its decision on the innocence or guilt of the accused in due course.